Well, hello everybody, and welcome to this webinar. I'm Stephen Hockman, Head of Chambers at Six Pump Court, and we're delighted to have you on board for this presentation. And I'm pleased to be joined by three of my colleagues, Paul McGarry, Stephen Walker, and Chris Badger. Unfortunately, Anna Cancelis, one of our associate members who was to have joined us, is indisposed today, but we'll do our best to cope and to cover the ground. And as you know, this is one of a series of webinars on international arbitration, which we have arranged. The first one was towards the end of last year. This is the second, and there will be, I think, at least a couple more of which you will receive notice in due course. This particular webinar on the topical topic of international arbitration and climate change, we're very much looking forward to. And as I say, the speakers, who will each speak for 10 or 15 minutes or so, will be Chris Badger first, my colleague who is a specialist in environmental law, Paul McGarry, based in Dublin, an international arbitrator and litigator, and Stephen Walker, based in Western Australia, who acts as counsel and as arbitrator in many international arbitrations. As usual, if you have some questions, please type them into the Q&A box, and we'll try and deal with those at the end of the session, which will last about an hour in all, I think. And when we're finished, we will send out the recording. Each of these webinars is being recorded. We'll send out the recording, and we'll also try to send out papers, those which are available relating to the topics which we have covered, so that we hope that the session will not merely be interesting, but useful for you going forward. So without further ado, I will hand over to my colleague Chris to make the first presentation.
Thanks, Stephen. So I'd like to talk first of all on key trends and issues in climate change litigation. As we've grown increasingly aware of the need to tackle climate change, governments have responded through the use of international agreements, such as the 2015 Paris Agreement and the 2030 Agenda for Sustainable Development with its Sustainable Development Goals. And governments have also responded through domestic regulation to mitigate greenhouse gas emissions and adapt to the impacts of climate change. However, greenhouse gas emissions continue to climb. That has in turn led to an increased frequency and diversity of legal actions addressing climate change, including those that are premised on regulatory responses to greenhouse gas emissions, and others that arise out of extreme weather events and the physical impacts of climate change. The United Nations Environment Programme, UNEP, has identified that as the energy transition develops, policy in the form of regulatory reform and market drivers, such as economic impacts and ESG disclosure requirements, are likely to present material litigation risk exposures to corporations, asset owners, and their insurers. Now, such litigation risks may arise from claims by private parties who have suffered loss or damage due to a market participant's failure to manage or disclose energy transition risks, and also investigations or proceedings by government or by regulatory bodies. This in turn may have material impacts on financial risk return factors at all levels of the investment supply chain. Now, it isn't actually that difficult to identify the types of climate change litigation that we will see. Cases will encompass challenges to national policy, international disputes, particularly those that feature in the European Court of Human Rights, adaptation style cases, including against national governments for failing to mitigate risk in time, corporate governance actions for failing to address known climate risk, or failing to provide sufficient information on addressing climate risk. Fraud claims relating to company disclosures. Breach of fiduciary duty claims against individual directors for failing to properly address climate risk. Product liability claims for products and or their processes that contribute to emissions. And also nuisance claims resulting from the impacts of climate change. And so with those categories in mind, it is a useful exercise to have a whistle-stop run-through of the most recent and current global cases related to climate change, not least because they give us a view on how this important area of litigation will develop. First, one that almost everyone's heard of, agenda. The Dutch Supreme Court found that the Dutch government was in breach of Articles 2 and 8 of the European Convention on Human Rights, and consequently its duty of care to its citizens, by putting in place a domestic policy with a target for emissions reduction, which was below that to which the Netherlands had committed on an international level. The concept of protection wasn't limited in that case to any specific persons, but to society as a whole. And the obligation to take appropriate steps included a duty on the state to take preventative measures to counter environmental damage, even if the materialization of that danger is uncertain. To meet its duty of care, the Netherlands had to commit to at least a 25% reduction in emissions. The measures on how to do that were left to the state. The key point to take from the case, which on one view might be regarded as a little fact specific, is the extent and reach of Articles 2 and 8 in the context of global warming, and the global shared responsibility which eliminated the need to answer difficult questions of causation. The second case to draw to your attention is the Friends of the Earth Netherlands against Shell. It's currently going on. It's alleged that Shell's contribution to climate change violated the company's duty of care under Dutch law and human rights obligations. A ruling is being sought that Shell must reduce its CO2 emissions by 45% by 2030 compared to 2010 levels, and to zero by 2050, in line with the Paris Agreement. And hearings took place in December. The case attempts to extend the agenda decision, principally on the duty of care, to private companies, and if successful, could provide a precedent for similar actions against virtually any greenhouse gas emitter. Third, Duarte Agostinho and others against Portugal and others in the European Court of Human Rights. 6 youth applicants have filed a climate dispute in the European Court of Human Rights against 33 defendant countries, which include the UK. The case has been fast-tracked, and the defendant companies have been ordered to respond to the complaint by the end of this month. The essence of the complaint targets alleged inadequate legislative or administrative measures in relation to the export of fossil fuels and the need to regulate to keep global warming to 1.5 degrees C, the offsetting of emissions for imported goods, and the contribution to the release of emissions overseas. The obvious question in the case is how to determine the issue of adequacy. The novel argument in that case that's being put forward is as follows. Member states have a presumed responsibility with regard to climate change. Current mitigation measures must be presumed to be inadequate because global warming is on course to vastly exceed the 1.5 degree target. Consequently, any uncertainty as to the fair share of the contribution between member states can only operate in the applicant's favor and not assist those member states. It's going to be very interesting to see whether or not that actually has any traction. Fourth, involving a superannuation fund called REST in Australia. In November 2020, Australian pension fund REST, which is a 56 billion Australian dollar retail employees superannuation fund, settled a climate change related litigation brought against it by one of its members. The settlement involved the fund making several commitments relating to climate change, including implementing a long-term objective to to achieve a net zero carbon footprint for the fund by 2050, publicly disclosing its holdings, and enhancing the consideration of climate change risks in its investment strategy. And the principles on which the case was brought are likely to have a lot of parallels with UK trustee fiduciary duties, particularly as we see an increase in regulation in this area. The next case to draw to your attention is an American case called Harris County and Arkema. Severe flooding caused a facility to lose power and to become unable to properly refrigerate certain chemicals that were being stored at the facility. That in turn led to an explosion and significant emissions to air of toxic chemicals. The case is that the facility negligently ignored the flood risk. The role of climate change is likely to be an important consideration for the court. What's also interesting is that there are now over 750 plaintiffs who've joined the case, and that has obviously the potential to significantly impact on the cumulative award of damages if the chemical facility loses the case. Finally, again, another American case, York County and Rambo. The central argument in this case is whether the utility company, Pacific Gas and Electric, misrepresented its efforts to address wildfire risks in securities offering documents. It's alleged that the company failed to disclose the elevated risk caused by the company's own conduct, including failing to comply with applicable regulations on the maintenance of electrical lines in circumstances where events such as droughts linked to climate change are becoming much more frequent. So to conclude, if nothing else, these cases are not going away. Jess Staley, the boss of Barclays, said this morning to the BBC, "Climate today is like technology was in 1995. If you think about it, all the Amazons, the Googles, didn't really exist in 1995, and now it dominates 40% of the economy. I think it's a fair argument that dealing with climate and dealing with the environment is in the same position now." Thank you.
Thank you very much, Chris, for that splendid introduction to dispute resolution in general. And now I'm going to hand over to Paul, speaking, as I say, from Dublin's Fair City, and invite you to give us your contribution. Paul.
Thank you, Stephen, and thank you for the opportunity to participate in what is a very interesting topic, and one that's, I think, close to all our hearts as we move forward. So we know, obviously, that the Paris agreements aren't binding directly on the states that signed them, but as Chris has said, there are plenty of ways around that. And indeed, many countries have started to incorporate some of the obligations into domestic legislation. And I think that's something you're going to see more of in the future. You've seen some of the political signalling in the UK, the European Green Deal in the EU is another example. I'm not going to say anything else about that because my focus this morning is on international arbitration, and particularly with an emphasis on the approach taken by the arbitral institutions. And the inherent flexibility and the international nature of the process makes commercial arbitration, of course, an ideal dispute resolution method for climate change and environmental disputes, because almost invariably there is an international dimension. And as is frequently restated, most of the reasons why arbitration is such an attractive concept in general, speed, independence, party control, seamless onward enforcement, can be applied to environmental disputes. The concepts themselves are broad, and disputes arise in a myriad of forms. They range from claims against governments and major carbon emitters to investigations launched by governments themselves. Some types of climate-related disputes may, of course, not lend themselves easily to arbitration. However, disputes with an environmental component can also arise in the context of contractual and commercial disputes, that are typically resolved through commercial arbitration. And these are, I think, the most interesting ones for practitioners. And some examples of how this can arise. Contracts, for example, in the energy and engineering sectors where there are alleged breaches of obligations to comply with emissions rules, or where national laws impose implied obligations. There are obvious examples can be thought of where parties allege breaches of contract for failure to comply with those rules in the delivery of the contract. Another example is loan or investment agreements for specific climate reduction measures. And again, all governments, in keeping with the Paris Agreement, are trying to encourage investment in climate reduction measures. Shareholder claims against companies for failing to adequately disclose the environmental impact of their operations. We've seen some of those in recent years. And of course, there are large-scale insurance claims that arise following natural events. There are, of course, also public or quasi-public law claims against companies or governments for breaches of human rights rules, and claims against governments to accelerate climate change prevention to directly comply with the Paris obligations. And again, Chris has spoken a little bit about that. So how have the arbitral institutions responded? Well, the ICC was out ahead of everybody else with its report published in November 2019. It is, in fact, a very good document. I probably sound surprised in saying that, because often these reports from international bodies can be fairly turgid. But this is, in fact, comprehensive. And interestingly, it's filled with practical, hypothetical case examples. So I would encourage anybody with an interest in the area to read it. As you'd expect, the ICC tells us that it is itself ideally placed to provide a forum for dispute resolution, given its history and global reach. But it also highlights the big issues for the arbitral institutions that need to be considered. For example, the flexibility of the process. It should be capable of being adapted to allow for complex disputes, either involving different parties or where multiple related issues arise. This is important, for example, in the energy sector, where there are often many contracts related to the same factual thing. Another issue, because the disputes themselves can be very technical, the parties have the possibility to ensure that there is expert involvement in the process at the tribunal level. And then a big issue is transparency. The report highlights the fact that parties are, of course, free to agree to things like award publication, and it talks about building a database of these types of disputes. And although the report itself didn't provide for any specific rule changes, the ICC rules were in fact amended in December of last year, coming into effect on the 1st of January. These make provision for a number of changes, including the type of greater flexibility in the process, joinder of multiple claims, involvement of third parties, and so on. The rules themselves don't address transparency, but I think it's worth pointing out that the ICC recently issued a data notice in which it said that from 2021 onwards, it intends to publish awards on a default basis, subject, of course, to the right of the parties to signal that they don't consent to that. And that's a genuine innovation, because transparency remains a problem with arbitration generally. And there has always been a tension between the attraction of confidentiality for the parties on the one hand and the need to see how disputes are resolved on the other. Publication, as we know, is generally patchy. ICSID, for example, publishes its awards online, but I think we're going to see a little bit more of that, particularly in areas that are conceptually important and have a global feel, like climate change. Given that the vast majority of commercial arbitrations are confidential, it's difficult, therefore, to identify trends with respect to the tribunal's treatment of environment-related considerations. And the global push for increased transparency in these type of arbitration will result in increased publication of awards, which then allows interested parties to follow the treatment of these considerations more easily and closely in the future. And this then, the circle will continue, should generate more awareness of the benefits of using arbitration itself. Then just some other institutions. The Permanent Court of Arbitration has taken a more direct approach to climate issues. It has, for many years, had rules specifically designed to attract users who have climate related disputes. It has also administered a number of disputes relating to the Kyoto Protocol. And there is, I should say, an optional set of rules that have been drawn up for arbitrating human rights disputes, dating from, I think, December 2019, known as the Hague Rules. The LCIA has new rules since the 1st of October of last year, and the focus of these is in allowing for more power and increased flexibility to the court and the tribunal, for example, to consolidate arbitrations where they are brought under compatible arbitrations agreements arising from the same transaction or series of related transactions. And there are also new provisions in relation to third-party issues, multiple claims, and so on. And other institutions have taken similar general approaches. I understand Singapore and Hong Kong have also been looking at this question of transparency. It's also, I suppose, not trite to say that all of the institutions are trying to be seen to be improving their own individual carbon footprint by encouraging more online communications, virtual hearings, and of course, travel reduction, although I think it's fair to say that a lot of that obviously hasn't been voluntary in the course of the past 12 months. But the thing to remember about commercial arbitration is that it is all party-led. The vast majority of disputes will have a contractual agreement to arbitrate. As the ICC report recognized, it might be possible to enter into an agreement for the purposes of resolving a dispute after the issues have arisen. And there may well be more of these in areas like climate change, where some of the disputes refer specifically to international standards, like Paris, or even because of the lack of symmetry between the parties, for example, where you have groups of individuals or an NGO on one side and a large corporate body or a state on the other. What we do know about arbitral awards is largely derived from investment treaty cases like Allard in Barbados, Avon in Costa Rica, Cortic in Kenya, and that's not an issue that I'm going to deal with. But outside of that area, there's almost nothing in the way of published decisions. But whatever the dispute, it's clear that the institutions want to be seen to be out front in making it easier for them to be resolved. And they've already done quite a lot of work in this area. Of course, these issues have, like everything else, had to yield in importance to the pandemic in the last year. But once that's resolved, you're going to hear an awful lot more about climate disputes and arbitration. And just to give you an idea about how much this is still in its infancy, maybe at the macro level, go back to the Paris Agreement. The agreement itself provides for a form of dispute resolution by reference to Article 14 of the UN Framework Convention under which it's made. And this envisages disputes either being referred to the International Court of Justice or a scenario whereby an arbitration process is created by the parties, but neither of those things have actually happened yet. So thank you, Stephen. That's all I wanted to say.
Thank you very much indeed, Paul. Now I have pleasure in handing over to our colleague from the Pacific region, I suppose we could call it. Stephen, you're in Perth, I think, if I'm right, and please do make your contribution now.
Thank you for that kind introduction, Stephen. I have to confess at this stage, I'm not actually Australian. I'm originally from Edinburgh, as you can probably tell. But it's well into Friday evening here, ladies and gentlemen, and a very good evening to you all from Western Australia. Investment treaties are bilateral or multilateral agreements between states, which assure a degree of mutual protection of investments made in one state, the host state, by investors from the other state, the home state. These treaties will contain protections against, for example, expropriation by the state and unfair treatment of the investor, which is enforceable by the investor through international investment arbitration. I first became interested in investment treaty arbitration 20 years ago, when I was involved in the first ICSID case under the Energy Charter Treaty, AES, against the Republic of Hungary. Of course, a lot has happened in 20 years. There are now over 3,300 bilateral investment treaties known as BITs, in force alongside a smaller number of significant multilateral investment treaties, for example, NAFTA, or now the USMCA, and of course the Energy Charter Treaty. An investor also needs to consider if there are any helpful foreign investment laws or investment agreements, for example, free trade agreements, which might also offer investor protection. Whilst there was a fair degree of international consensus and therefore similarity between the terms of these treaties in the 1980s and the 1990s, a greater divergence of terms has emerged over the past 2 decades. Each investment, therefore, must be examined on its specific facts and the terms of the relevant treaties, preferably before the investment is structured and made. There are 3 key issues to consider for investors in relation to investment treaties. 1, what investments qualify for protections? 2, what protections do the relevant treaties provide? And 3, how those protections may change. Dealing with the first one, what investments qualify for protections? When considering how to structure an investment to benefit from an investment treaty protection, one must carefully consider the treaties which apply to the location being considered for investment and the scope of application of such treaties. As a basic framework, the 2 issues in relation to scope are this. 1, is there a qualifying investment? And 2, is there a qualifying investor? So, is there a qualifying investment? Treaties tend to cast the net very widely in terms of what constitutes qualifying investments. ICSID case law has interpreted investment in the context of the ICSID Convention to depend on the following 4 elements, albeit not all 4 elements are always required. These are, number 1, a contribution of money or assets; 2, a certain duration, not merely a short-term duration, an element of risk; and 4thly, a significant contribution to the economic development of the host state. In particular, the 4th factor has not been universally applied. If an investor is in any doubt as to the qualification of an investment being made, but is dealing directly with the state or the state entity, it would be well advised to bargain for contractual protections and subject them to commercial arbitration. Of course, this is just normal good practice and part of the bigger picture of mitigating risk and protecting the investment. Secondly, is there a qualifying investor? The scope of investors protected by investment treaties has been the subject of particular controversy in the context of the often complex investment structures employed. For traditional BITs, mere incorporation in a home state is likely to be enough. For example, in the cases of, these are ICSID cases, Aguas del Tunari against Bolivia, US and Italian companies formed a JV incorporated in the Netherlands, which operated a Bolivian water company. The tribunal held the Netherlands JV was able to bring a claim under the Netherlands-Bolivia BIT. The next case is Turkie's against Ukraine. This was a Lithuanian company, was held to be a qualifying investor to sue Ukraine, even though 99% of the shareholders and 66% of the company management were Ukrainian. Therefore, under many treaties, it will be permissible to incorporate a company in a home state in order to invest in a host state. This means that investors considering foreign investment should carefully consider how to structure projects in order to maximize their treaty protection. with any corporate structure, there will also be tax consequences, which must also be considered and certainly not forgotten. Indirect investments generally qualify, for example, a home state company holding a minority stake in a host state company. In the case of CMS against Argentina, a US company held a 30% stake in an Argentinian utilities company. The tribunal found jurisdiction where a treaty's definition of investment includes equity, stock, or shares in the company. A minority shareholder has a direct right of action against the host state that can be asserted independently from the rights of the company itself. However, tribunals may not recognize jurisdiction under BITs, where reorganization occurs after the investment has been made and once a dispute has arisen or is anticipated. In Philip Morris Asia Limited against Australia, where Philip Morris reorganized to incorporate in Hong Kong in order to challenge tobacco legislation, the tribunal found this to be an abusive process. A common way investors structure projects to secure protection from investment treaties is to have layers of shareholdings in various jurisdictions. This has been a successful way of widening the range of possible investors, as tribunals have traditionally extended the interpretation of investment to include indirect shareholdings through an intermediate company, or to even allow claims from the ultimate beneficial owners of a corporate structure. So what are the protections? There are several protections, but there are three classic protections in most of these investment treaties that we'll all be familiar with. Firstly, the host state will not expropriate the investment without payment of prompt, adequate, and effective compensation. Secondly, the host state will not subject investments to treatment less favorable than which it accords to investments or returns of its own investors, or to investments or returns of any third state. Thirdly, the host state will ensure fair and equitable treatment of the investor and afford its investment wider protection, generally based on expectations of the investor and promises of the state. In the NAFTA case of waste management against Mexico, this is from a NAFTA tribunal in 2004, the tribunal defined fair and equitable treatment as being breached where conduct is arbitrary, grossly unfair, unjust, or idiosyncratic, is discriminatory, and exposes the claimant to sectional or racial prejudice, or involves a lack of due process, leading to an outcome which offends judicial propriety. The final protection has proved to be the most controversial, with many states now removing it from their future treaties and or renegotiating old treaties to remove the protection. This is to give the state more flexibility and also to reduce the risk of enormous investment treaty arbitration awards. The largest investment arbitration award was about 40 to 50 billion US dollars. There are about 50 known investment cases so far where the awarded compensation exceeds $100 million. These are truly enormous sums, especially for the developing world to deal with. These are greatly in excess of some countries' entire annual budgets on education and on health and so on. So, what are the more recent developments in investment treaties? Well, there have been retreats from the height of investment treaty protection. There are restrictions on what qualifies as an investor. For example, the new Netherlands model BIT requires a legal person incorporated under the law of the relevant state to have substantial business activities in the territory of that state to qualify for protection. This is likely to reduce the opportunities for treaty shopping in the future. Investors should be wary of attempts to renegotiate treaties relevant to their prospective investments. There has been withdrawal from treaties and, in fact, from ICSID. Venezuela, Bolivia, and Ecuador have left the ICSID Convention. A number of other agreements continue to be terminated, and looking as far as the year 2018, with at least 24 terminations coming into effect in 2018, including 12 BITs terminated by Ecuador and 5 by India. Fortunately, treaties will usually have notice periods for withdrawal or change, often 12 months, in addition to continuing to apply to existing investments for 10 to 15 years after termination. But there's a scaling back of these protections. Various states are amending or replacing old-style BITs with modern versions which tend to reduce the protection of fair and equitable treatment, reduce or limit the right to dispute settlement, or emphasize exceptions for environmental protection or other state interests. Many treaties now require an exhaustion of local remedies before commencing arbitration, and tribunals have been willing to enforce this as a requirement of state consent to arbitration. For example, the US, Canada, and Mexico have scaled back the protections and access to dispute resolution under NAFTA that was available under NAFTA under the current US MCA, cutting protection against indirect expropriation, protecting a state's right to regulate, and requiring pursuit of proceedings in national courts first. So, ladies and gentlemen, in conclusion, there are plenty of advantages and plenty of ways to structure an investment and to mitigate risk. But do remember to read the treaties. Do remember to look out for foreign investment laws and investment agreements, and structure the investment before the investment is made in order to avoid problems. And always make sure you check that the proposed structure is tax efficient. Thank you very much, ladies and gentlemen.
Thank you, Stephen, for that very comprehensive review of investment treaty issues. And now for our fourth and final presentation, and in the absence of our colleague Anna, who, as I said earlier, unfortunately can't be with us today, I'm going to return to Chris Badger to at least summarize and cover some of the ground that I think Anna would have intended to cover, and we'll see whether we can send out a paper from her in due course. But for the moment, back to you, Chris.
Thanks, Stephen. I just wanted to speak for a few minutes on whether investment protections are a barrier to or enabler of decarbonisation, and sort of link Stephen's talk sort of back to my initial presentation. I mean, the fact is that now sustainable development and addressing climate change are policy priorities that are embedded in regulatory frameworks at both international and national levels. And states have committed to the Paris Agreement to limit warming to 2 degrees C and to pursue efforts to limit to 1.5 degrees C. And it is an urgent issue. We're living in the critical decade. Global emissions have to be halved over the 2020 to 2030 period if the Paris goals are to remain in reach. So from that perspective, financial flows, both public and private investment, will need to be aligned with policy objectives for economies to be able to transition at the necessary scale and speed. And states have committed in the Paris Agreement to making finance flows consistent with a pathway towards a low greenhouse gas emissions status and climate resilient development. But the transition needs money. And both public and private economic actors have to move investment flows away from investment in high emitting projects, particularly those that relate to fossil fuels, and towards carbon neutral and low emission projects, such as renewables, such as energy storage in climate resilient infrastructure. And the energy sector is not the only relevant sector here, but it is a critical one. The estimate for the amount of investment needed for decarbonisation, for the low energy transition in energy systems alone lies between 1.6 trillion US dollars to 3.8 trillion US dollars per year from 2016 to 2050. And yet, despite this, fossil fuel investments continue to grow. And public funds alone won't be enough to meet climate goals. Private finance and foreign direct investment have a crucial role to play. Now, in theory, international investment law and policy frameworks and institutional settings should enable and expedite rather than hinder the transition. In this context, and looking specifically at investment treaty protections and investor-state dispute settlement, in this context, they support decarbonisation. They provide a degree of certainty. So ISDS allows a foreign investor to resort to international arbitration to seek, almost always, monetary damages from the host state for violating substantive rights, typically without the need to first exhaust local remedies. And so managing risk can positively impact on the risk profile of an investment and can attract investment, in particular if there is less financial and political risk. But to counter this, or the counter to this, is that investment treaty protections and ISDS tend to favour the incumbent, which in this case are the high emission projects. And the risk of legal action can cause governments to fail to introduce the regulation needed to meet net zero and carbon goals, known as regulatory chill. Now, ISDS claims have been brought by both sides. The fossil fuel industry, see, for example, Vattenfall, Westmoreland, Uniper, or the renewable industry, the Spanish solar cases spring to mind. So the answer to the question is that it currently cuts both ways. But perceived benefits of IIAs or ISDS are not limited to renewable energy. They're not limited to green sectors, and they can make it difficult for states to innovate. It would not be a surprise to see future international investment agreements drafted in such a way as to emphasize and facilitate the need to reach climate goals. Thank you.
Thank you very much indeed, Chris. Now, may I continue to invite people to submit questions through the Q&A. We do have one or two questions already, and I'm going to put the first one to the panel and invite comment and discussion on it. I think this is a question principally for Stephen Walker, but I'll invite Paul and Chris to chip in as well. So this question, Stephen, I think is really about trends. And the question is whether investment treaties generally, and hence investment treaty arbitration consequentially, are likely to become more or less favoured as the years go by. And I suppose relating it specifically to the environmental aspect, and to some extent echoing one or two of the points that Chris was making just now. Do you think that the growing emphasis in commerce, and for that matter in policy, on environmental issues and environmental protection, do you think that's going to make investment treaty matters more popular, more interesting for business people, and for that matter politicians generally? Or do you think there may be a discouraging effect as a result of those developments?
I think you have the answer to your question is yes and no. Yes, very, very popular indeed with investors. No, not so popular with the states that have to pick up the tab for all of this. I was looking at the UNCTAD, the UN Trade and Development website earlier on, and they announced on the 7th of April 2020 the number of investment state arbitrations arising out of the international investment agreements. And they had calculated there had been, by the 31st of December 2019, a whopping 1,023 investment arbitrations. It's been hugely popular for the investor. You can see if you look at some of the figures, the eye-watering figures. Hully Enterprises against Russia, 40 billion award. ConocoPhillips against Venezuela, 8.4 billion. Veteran Petroleum against Russia, 8.2 billion. And my last one is a good example, Tethian Copper against Pakistan, 4 billion, which is exactly the amount that 2 months earlier, the government of Pakistan had gone to the International Monetary Fund for a financial bailout. So these are huge, huge awards, which if you're the state, of course, you would be trying to minimize these protections, make them less vague, make them more restrictive, put up more hurdles. But certainly, as the investor is concerned, it's been hugely popular and very successful. And to be fair to the investor, can provide remedies and excellent remedies where no remedies may exist.
Thank you. I don't know whether Paul or Chris would like to comment either on what Stephen has said or more generally on this issue of trends in investor-state arbitration. Let me go to who wants to start? Chris.
Yes, just to highlight something really from the state's perspective, which is the rise of the environmental counterclaim. It's not unknown now. Paul mentioned Avon and Costa Rica. It's not unknown for states to assert that environmental damage has been committed by the investing companies and to raise that as a live issue during the course of the arbitration. So from an environmental perspective, I think that is likely to only increase going forwards, particularly in light of the popularity of these types of proceedings.
Paul?
Yes, Stephen. I think what it comes back to is the difference in approach that's taken from state to state. Stephen mentioned earlier the very significant differences there are in the approaches taken by different states, by reference, for example, to the Dutch BIT example. So I think the reality is that you're looking at a situation where certain developed states will want to see the type of obligations met by investors that could potentially give rise to the type of counterclaims that Chris talked about, whereas others are perhaps looking at it from the other perspective, say, how do we avoid getting hit for claims running into the billions? But the trend seems to be the more developed the state, maybe I'm wrong about this, Stephen would know better than me, but the more developed the state, the more political the need to ensure that the treaties themselves contain different types of protections.
Stephen, do you want to come back on either of those comments before we go to the next question?
I think it's both. I think the developing world want to appear for all sorts of very good reasons that they're pro-investor and pro-global trade and so on. So they're happy to amend and restrict and redraft their various investment treaties. But of course, some of the poorer countries are actually quite happy to just withdraw. They're just, as I gave the example of India and also Venezuela and Ecuador and so on from the ICSA treaty, they're actually just happy to withdraw. And of course, it used to be the case that these investment treaties were there fundamentally to give foreign direct investors confidence to invest. But I think the reality these days is in most of these countries that if the investment return is significant enough, it won't matter whether there's an investment treaty or not. Parties will go in, and foreign investors will go in, as they have done for many years, and exploit the investment.
Thank you very much. Now, we've got time, I think, for one or two more topics, and let me just have a look at a question that's been raised by a member of the audience. It sounds like an interesting one, so I'll read it out and see what your comments are. The questioner says this: in response to the threat of regulatory chill in favor of incumbent high carbon emitters, does the panel anticipate arbitration tribunals taking increasing account of developing science to refuse claims? Are there perhaps parallels with the Philip Morris decision, which I think Paul mentioned, where in a very different context, the tribunal showed willingness to take into account public interests when reaching its decision? So anybody care to have a shot at that one? Paul, is that something that you could address?
I mean, again, it's quite difficult to be specific when you talk about developing science being used to refuse claims. I suppose from my perspective, one of the advantages of institutional arbitration and the innovations that we are slowly seeing coming on stream is the guarantee that the parties have in relation to the composition of the tribunal, ensuring that there is sufficient expertise available to deal with issues as they arise. If, for example, there is an issue, say, about science that could be relevant to whether a claim is a valid claim or can be prosecuted or comes within the terms of the dispute at all, if it's, for example, a jurisdictional issue or a standing issue or something like that. I don't know if that answers the question.
Thank you very much. Chris?
I would say that as far as I'm concerned, this would be a matter of expert evidence, and I think I, as counsel, would be more comfortable with it being a matter of expert evidence. And I think if I was sitting as the arbitrator, I'd actually be more comfortable with it being a matter of expert evidence. At least the information that I'm taking a decision on is before being presented to the tribunal.
Thank you very much. Right, we've got time, I think, perhaps for one more topic, one more issue, and this might be another one, Paul, for you to start with, but everyone may have a comment to make. So, Paul, in your presentation, you adverted to the fact that very often in international treaties relating to environmental issues, there is some form of dispute resolution clause, and you mentioned the UNFCCC itself, and you mentioned the Paris Agreement. But I suspect that it has been fairly rare for disputes, even though, as it were, authorized by those types of clause, to actually find their way to any form of existing international tribunal, such as the International Court of Justice, which, as we all know, has dealt relatively rarely with environmental issues. And we don't have, or we don't yet have, an international court for the environment, which some of us might welcome. On the other hand, the prospect of those issues being ventilated in the form of some form of arbitral tribunal is certainly an interesting one. One might think that arbitration was the ideal kind of forum for these issues to be dealt with, and one might think that it would very much be in the public interest for there to be rulings by arbitral tribunals on this sort of issue, so that there could be a balance struck between the need for environmental protection on the one hand and the need for continuing and even more resurgent economic development on the other. So I suppose the question is, how does one encourage the penetration of arbitration into this sort of area, seeing how useful and suitable it might be?
Yeah, I mean, you're absolutely right on the premise. As I said, I mean, Article 14 of the UNFCCC provides an alternative mechanism for the creation of an arbitral system, or an arbitration system, but that's never happened. Obviously, the notion of a global environmental court has been tossed around from time to time, but I think when you read the Paris Agreement and when you talk to people who were involved in the drafting of it and so on, you'll see that that was the kind of thing they were never going to be able to get any agreement in relation to. But I mean, I think one of the things that comes out of this particular webinar is that there is a very, very diverse range of types of disputes, parties to those types of disputes that can arise even in an international context. So whether it's investment treaties, whether it's claims that are prosecuted, as Chris said, in national courts involving state obligations, or whether it's commercial dispute resolution as we understand it, where you have contracts with arbitration clauses, and yet they give rise to, or international obligations can be seen to be incorporated into them. So I think the difficulty is a one-size-fits-all probably doesn't work. And that's, I think, why the institutions have been trying to encourage more people to look at using their existing systems, adapt their rules to the extent that it's possible to do. And of course, that issue about transparency, publication of awards is I think, in this particular area, crucial. I mean, a lot of people don't like the idea of the confidential nature of the arbitration proceedings, but an awful lot of clients, particularly large corporate clients, multinationals, banks, people like that, it is the one reason why they love international arbitration. They love arbitration because it is all confidential. But I think there's a medium between ensuring that remains the case, whilst at the same time getting some measure of information out about the types of decisions that are being made, particularly where they relate to kind of macro issues like climate change, like environmental protection.
Thank you very much indeed. Well, unless
I suppose, just very quickly, I think that's been the tremendous success, or one of the most tremendous successes of ICSID arbitration, which, if you look at the exponential increase in cases over the last 20 years of people going to ICSID and embracing ICSID. And the great thing about ICSID is you go onto their website and you can exactly see the investors suing the particular states. And they produce the case reports. You can actually read what the tribunal decided in relation to particular issues. It's a very public way to arbitrate. And it seems to me it's quite an effective way of getting states to change their behavior. And that's why it's been embraced so much so by investors.
Thank you very much. Well, I think we've come to the end of our time. On behalf of the audience, I would like to thank each of my colleagues for their fascinating presentations and for the work that's gone into preparing them. On behalf of all of us at Six Pump Court, I'd like to thank those of you who have been kind enough to attend today's event and to listen to what we've all had to say. We will undoubtedly stay in touch with you. We will send you the recording of this webinar and any available papers, and we will certainly send you information about further webinars in this series. So thank you all very much indeed for attending, and wherever you are, whether it's good morning or good afternoon, we wish you well. Thank you.